I'm Jen Taylor Skinner, and this is the Electorette. On this episode, I have a conversation with Alexandra Brodsky. Alexandra Brodsky is a civil rights attorney and author of the book Sexual Justice: Supporting Victims, Ensuring Due Process, and Resisting the Conservative Backlash. Alexandra joins me to discuss the Biden administration's forthcoming changes to Title IX. Title IX is a law that prohibits sex-based discrimination in schools and other educational settings that receive funding from the federal government. And if you'll recall, these protections were stripped under the Trump administration at the hands of Betsy DeVos, the former Secretary of Education. But the Biden administration is expected not only to roll back those changes made under the Trump administration, but to expand protections. Alexandra and I discussed the history of Title IX, including changes that were made under President Obama and what she hopes to see in the forthcoming changes under President Biden. So without further ado, here is my conversation with Alexandra Brodsky. Alexandra Brodsky, welcome.
Thanks so much. Thanks for having me.
So can we just start with the basics with Title IX? When it was originally passed, what is it, how is it supposed to function, and who it's supposed to protect?
Absolutely. So Title IX, as of this month, is a 50-year-old law. It was passed in 1972, and it broadly prohibits sex discrimination in education. And it was one of a number of civil rights laws that were passed in the 60s and 70s in response to systemic inequalities. The law is really actually pretty short. The meat of it is really just one sentence that says, hey, no one should be subjected to sex discrimination in education. But it has been interpreted by courts, rightfully so, to have really sweeping ramifications that because it's worded so broadly, courts have seen that it prohibits all kinds of sex discrimination, whether that be unequal athletic opportunities for men and women, discrimination against pregnant and parenting students, discrimination in dress codes. There are still a lot of schools that have different dress codes for boys and girls, discrimination against queer and trans students, and, requiring protections from sexual harassment. I think that Congress, when it passed Title IX, really had women and girls in mind. That's what the speeches made by Congress members at the time suggest. But what's important is that Title IX protections aren't just limited to those people in particular. We have seen Title IX offer really important protections for men and boys, including men and boys who have been sexually abused in school. We have seen that it's offered really important protections for non-binary students. And we've seen that it's not just students who benefit. It's also coaches, it's also teachers, it's also school staff.
So it was originally intended as an amendment to the Civil Rights Act of 1964. Was there any specific case or incident that precipitated expanding the language to include Title IX?
Interestingly, Title IX is actually not an amendment to the Civil Rights Act. It's an amendment called the 1972 Education Amendments. And I think it was actually responding in some ways to a gap from the 1964 Civil Rights Act, which had prohibited sex discrimination in employment, and it had prohibited race discrimination in education and employment and other parts of life, but it had never prohibited sex discrimination in education. And so we continued to see these really unacceptable inequalities in schools, but they were legal, especially in private schools, which aren't subject to the Constitution's guarantee of equal protection. That kind of discrimination was just totally legal. So we saw a number of schools that continued to exclude women from, campus altogether. There's a really famous Title IX case that made its way to the Supreme Court against the University of Chicago, which just wouldn't allow women to apply to their med school. I think it's really wild to think about 50 years in the grand scheme of things is not that long ago. But education looked so different. It was taken for granted that on the higher ed level, that education would often be single sex. It was taken for granted that even in K-12 schools, which have been, historically co-ed, that students of different genders didn't have the same rights to access to opportunities. It just made sense to a lot of people that boys would just have more access to athletics, let's say. And it took activists like Representative Patty Mink to, really shine a light on these problems and get Congress to do something about it.
So I just want to go to a more modern timeline of Title IX and the language that's included, because I think in 1986, there was an expansion of the definition of sexual harassment, right? How does that relate to Title IX?
In 1986, the Supreme Court for the first time recognized that sexual harassment is a form of sex discrimination that can violate laws forbidding sex discrimination. It was this case, Meritor versus Vincent. I talk about it a bunch in my book. There, the Supreme Court recognized that workers who are protected by this other law, Title VII, can bring suit if they have been sexually harassed. They had to meet other technical qualifications as well. But that was really a landmark case because up until that point, it had actually been controversial among the lower courts whether sexual harassment, in fact, was discriminatory. And so the Supreme Court made very, very clear yes, absolutely it is. And that, I should say, that obviously has a big impact on people who want to bring lawsuits. But to my mind, the most important impact of a case like that is how it changes employers and then schools behavior before anything bad even happens, right? So you can see in response to a big ruling like that employers started setting up systems for workers to file grievances when they had been sexually harassed, to seek remedies, to seek support. They started implementing training programs to stop sexual harassment before it ever happened. Then, when the Supreme Court extended that ruling about sexual harassment to schools, we saw schools start to build up the same kind of mechanisms. And because, of course, our hope is that there's never a need for a civil rights lawsuit in the first place because survivors in schools or workplaces or wherever they are getting the support that they need before they would even have to think about legal action.
Oh, I see. So that was Title VII. Okay. So back to Title IX. Under President Obama, there was an expansion of the protections under Title IX. Like, how significant were those and what was included?
That is, in some ways, a hard question because the Obama administration is really broadly credited with upping enforcement of Title IX against schools that were mistreating survivors. They did a couple of things. They put out what are called guidance documents, which are basically letters to schools saying, hey, we mean business. You have been responsible for addressing sexual harassment in your schools for decades. You haven't been doing a good job of that. So we're here to tell you, time to shape up. And then they also started more aggressively enforcing the law against schools that when students would come to the Department of Education and say, hey, my school isn't following Title IX, the Department of Education, separate from any lawsuit, would start investigating on its own. The Department of Education would go to campus, interview survivors, interview administrators, and figure out what the schools needed to do to come into compliance with the law and do right by their students. The one sort of disclaimer that I always feel the need to give here is that 99% of what was in these guidance documents from the Obama administration, that they were saying schools had to do, had been part of previous administrations' positions, both over Democratic and Republican administrations. So much of what was in those Obama era letters were also in letters from, 2001. Sometimes I want to give the Obama administration credit for doing really good work and also don't want people to get the sense that for the last decade or so, every new administration has had a wildly new vision of Title IX, when in fact, looking from, the 90s up through the Obama administration, this wasn't such a partisan issue. And the Department of Education was really consistent in its views.
Actually, now that you've described it, I'm thinking of myself as a college student in a university and thinking about this idea of guidance documents. And I know how unresponsive universities can be. And I can't imagine my own university responding to a guidance document. And just the idea of aggressive enforcement, how would a student get that forth?
That's a really important question. So Title IX is enforced in two ways. People who have been discriminated against can bring lawsuits in court. I think a lot of people have a vision of what that might look like. There are lawyers in a courtroom, all of that. But the Department of Education is also tasked with enforcing Title IX, separate and apart from that. And that's often a much more pleasant experience for students. It's not pleasant, but it's closer to pleasant in that less of the work falls on them. They don't have to hire a lawyer to represent them. What they do is that they basically write a letter to the Department of Education saying, here's what happened to me. Here is what I experienced. Here's what my friend experienced. Here's what students in general on my campus are experiencing. We think that this might violate Title IX. Can you come in and check this out? And that is sent to the Department of Education's Office for Civil Rights. There are some instructions about how to do this online. And the Department of Education then decides whether to open an investigation. And if it does, then it's really the department that is leading the charge. Students are not then tasked with gathering up all the evidence themselves because the Department of Education is much better positioned to do that. But I'll say that, when I was, you know, a student starting college, I had no idea that Title IX applied to anything other than, I don't know, women's soccer. I had no idea it related to sexual harassment. Certainly did not know that someone could go complain to the Department of Education, to the federal government, if they felt that they were being mistreated when they'd been sexually harassed. But I was approached when I was a junior in college by some classmates who were planning to file one of these complaints with the Department of Education. This was back in 2010, 2011. And we ended up filing, a Title IX complaint against our university with the Department of Education. The department came in, and while its investigation was far from perfect, it really did spur the school to change its ways. Because exactly as you're saying, sometimes a letter saying, please follow the law isn't enough. You need to know that enforcement has teeth in order to get moving as a school. And so once I had sort of gone through that process, I then started working with other students at other schools to share information about what does Title IX require and what can you do if you feel like your rights have been violated? What does it mean to file a complaint with the Department of Education? All of that. And we called this legal education campaign Know Your Nine. It has now grown up into a bigger organization than that does a lot of policy work as well. But I think that this just underscores that Title IX on the books is great, but it doesn't do much unless students really know about it, unless they know that they have these rights and what to do if they feel like they've been violated.
Right. I would imagine that most university students don't know that this exists and that there are some protections there under the, Department of Education. So enter the Trump administration and Betsy DeVos comes in. And, I was just thinking about her confirmation hearing. And if you watch that, you probably wouldn't have much confidence in what was coming next for Title IX. I remember that moment, where they were talking about guns in schools. And she said, some schools might need them to protect themselves against grizzly bears. Do you remember that moment?
I do. I mean, this was just so wild. I guess that this shouldn't have been any surprise, but Betsy DeVos did not have a background in education policy. She was a volunteer and a billionaire donor to the Republican Party, which seems probably explain how she ended up in her job, and also to some groups that were actually trying to privatize education. So to the extent that she'd worked on education issues at all as a donor, it was really not in the direction that we would have wanted her to. And yet suddenly here she was the top official for education in the United States, just couldn't answer basic questions that she was asked at her confirmation hearing.
Right, including how much her family had donated to the Republican Party. I remember there was a questions asking, has your family donated $200 million? She was like, I don't know, perhaps, right? I don't know the figure.
Like, oh, 200 million, that's just a rounding error. Who could know where that went?
But she was credited with gutting Title IX protections. What changes did she make?
Yeah, I mean, this is so disheartening to watch. When Trump came into power, we had just seen a couple years of really effective student advocacy that was building on and also pushing the Obama administration's work. So then Trump comes in, DeVos comes in, and actually a part of the Republican Party platform back when they had platforms when Trump was first running was to limit schools' responsibilities to student survivors. And, Trump and DeVos went ahead and put that into action. They passed these new Title IX regulations, and these are basically rules that are created not by Congress, but by a federal agency, but have the same force as a law. I'd put the problems with the regulations roughly into two buckets. So, one is that the regulations limited schools' responsibilities to survivors. They narrowed the definition of sexual harassment. They placed arbitrary geographic boundaries around schools' responsibilities so that if, a student was raped by a classmate across the street and then felt unsafe sitting in math class with the person who just assaulted them, the school would have no obligation to do anything about that at all. And this always sounds kind of silly to say, but the new regulation said that schools are allowed to respond to reports of sexual harassment in an unreasonable way. It used to be that under previous administrations, the way that the Department of Education would judge a school's response would be to say, well, did they respond reasonably? And I'll be honest, that makes sense to me. The Trump administration said, you're allowed to respond in an unreasonable fashion to reports of sexual harassment so long as it isn't clearly unreasonable. So long as you're not obviously doing a terrible job, you can still do a terrible job. So that was sort of one bucket of problems, really lowering the bar for what harassment schools have to address and how good a job they have to do in addressing it. And then separate and apart from that, I think this has gotten a little more press attention. The department imposed on colleges and universities specifically a one size fits all disciplinary model. where this doesn't apply to K-12 schools, but for colleges and universities, those schools are now required in investigating sexual harassment to use a process that looks a lot more like a criminal trial than it looks like student discipline in any other context. And to really, highlight this point, that means that students accused of sexual assault now have significantly more rights than their classmate accused of punching someone in the face or hazing or subjecting their classmates to harassment based on race or disability. This one class of students accused of sexual assault, are treated better than everyone else. And on the flip side of that, survivors of sexual harassment are subjected to this uniquely re-traumatizing process where often, they'll have their, a non-lawyer like their rapist's dad asking them questions about, well, what happened that night. And that really adversarial process dissuades a lot of students from coming forward in the first place. And again, that is not what students who are victimized in other ways beyond sexual violence have to put up with when they're on campus, and for good reason. So, unfortunately, these rules are still on the books. We are hoping that they are not long for this world.
Often under the Trump administration, there would be some group or a group of people who would directly benefit from changes like this. And for the life of me, I can't think of who would. I know that, people who've been accused, they would be behind it. But do you know if there's any particular group who would want to make a change like this and make life more difficult for survivors? I just don't understand.
Yeah, unfortunately, yes. So there's actually been really good reporting on this, particularly from The Nation, that men's rights activists had a direct line to the Department of Education and direct influence in shaping these regulations. These are not people who are concerned about due process in general. Look, I think that fair disciplinary proceedings are super important for sexual harassment or anything else. But these men's rights activists have sort of a funhouse mirror vision of the world in which the real victims of sexual harassment, to their mind, are all of the men, in their minds, always white men who have been falsely accused. I want to be very clear here that there is, in fact, not an epidemic of false allegations of rape. All of the best studies that we have suggest that rape is reported falsely no more often than other equivalent crimes. But I think that these people have a really twisted sense of male vulnerability and, often just think that rape isn't a problem at all or that women should just get over it. I think that they were really excited about these regulations because what it meant was that sexual violence was going to go unaddressed on college campuses. It was going to mean that, for in many cases, schools weren't going to have to do anything at all, weren't going to have to offer survivors any kind of support, forget about discipline. And in that, even in the cases where a school might have an obligation to come forward, that so many survivors were just never going to report because they would be so intimidated by those disciplinary proceedings. One thing I just want to flag is that these were not rules that helped accused students or accused professors in general. They really help wealthy accused people because they're really hard to navigate if you don't have a lawyer. So, just to give an example, these new proceedings require a live hearing that looks a lot like a trial, where there's direct questioning between the representatives for the two parties. So, what that often means is that whoever has a lawyer is at a huge advantage because if you can hire a lawyer to question, your alleged victim, they've been trained to ask the right kind of questions to trip someone up, all of that. But if you can't afford to hire a lawyer, then you're asking, your parent or your friend who doesn't have training to help you navigate this really difficult system. They have no idea what the right questions to ask are. And so this process has built in not only gender inequality, but also class inequality. Because, you talk to lawyers who are advocates who work within these systems, and they say that sometimes, often the best predictor of who the school is ultimately going to believe isn't who has the evidence, isn't who's credible, it's whoever can afford to hire the lawyer.
Is there any evidence to show that when these cases would come forward, that the accused would have more legal representation or better legal representation than the accuser?
I haven't seen research on this. It wouldn't surprise me, in part because we know that sexual violence is a way in which abusers exercise power. And so it's never surprising to me. We look at people like Brock Turner, the white Stanford swimmer, had sort of, every axis of privilege And, when we see him sexually assault a woman of color who was not enrolled at his fancy school, it's not surprising to me that someone like that will feel like they are entitled to other people's bodies, and in particular to women and women of color's bodies. So it would not be shocking to me if it turns out that, in fact, people accused of sexual harassment are in fact more likely to have access to wealth, but I haven't seen any kind of data to confirm that. And so I want to be clear here that I'm not saying that it's bad for people accused of sexual harassment or anything like that to have lawyers. I think the problem is that, and before these regulations, everyone was allowed to have a lawyer too. I think the problem is that the hearing, the investigation is set up in such a way that it is often too complicated for people to navigate without a lawyer. But because they aren't provided a free lawyer like they might in if you're talking about someone accused of sexual harassment or sexual assault in the criminal system getting a public defender, what that ends up meaning is that whoever has more resources, whether that's the survivor or the accused, is at a huge advantage. So I think it's just important because I think people talk about the Trump regulations as though they increased due process for the accused, but I don't think that they actually made the process fairer in any kind of global sense. I think that they just set it up so that people with money, people who can afford to hire an attorney, will be better able to protect themselves from a finding of responsibility, whether or not they did it.
I see, that makes sense. So we're nearing the 50th anniversary of Title IX. It's on June 23rd. And apparently the Biden administration is slated to overhaul these regulations. Do we have any idea of what's planned? How far will it go? And, what's the ideal wording or inclusion in Title IX?
A little bit of wonky legal background here. Because the Trump administration went through this years long process to set up its Title IX rules, which is this very formal process where it goes through a bunch of legal hurdles, the Biden administration now needs to go through those same legal hurdles to get rid of the regulations and hopefully to revise them to be better. And so I think a lot of students are understandably really frustrated that the rules didn't go away the first day of the Biden administration, but there are just a lot of obstacles to getting rid of these. So what we've heard now is that the latest reporting is that the Biden administration is going to propose its new rules this month in June. Now, they've been saying that for a couple of months now, but I hope that they really mean it this time. And once those new rules have been proposed, then the public will have the opportunity to comment on the rules, to say, here's what I like, here's what I don't like, this is what you're leaving out. The Department of Education will read all of those comments. Last time it was something like 100,000 comments. They're going to read all of those comments again that come in, and then they will publish their final rules, which might be revised in response to the public comments. And in terms of what I hope will be in there, I would like at the very least to see the regulations return to the previous better standards that we saw, not just under the Obama administration, but also under the Clinton and Bush administrations for many decades before the new Trump rules. So that means a broader definition of sexual harassment. That means that schools would have an obligation to address harassment that happened off campus but creates a hostile environment on campus. It would mean that schools are expected to do a reasonable job again. And it would mean that schools would be able to use the kind of disciplinary hearing models that they use for other kinds of discipline that are easier for students to navigate, that are less adversarial, that where it's less important whether you have a lawyer or not. I'm also hoping that the regulations will respond to some new challenges that we've seen students face over the last couple of years. As more students have started to learn about their Title IX rights, learn that they can come forward and report, we've also seen a lot more retaliation from schools. It is shocking to me how many survivors report to their schools and end up being the one punished. Sometimes because they drinking at the time that they were sexually assaulted and they have to disclose that to the school in order to report, and the school punishes them for drinking. Or I've seen a number of cases now where, a student reports that they've been sexually assaulted. The school says, we don't believe you, which means that you've just admitted to having consensual sex on our campus. And so we're going to, suspend you for that. So I'd love to see the regulations have really clear and robust anti-retaliation protections. Retaliation is already forbidden under Title IX, but I think schools need to understand what retaliation looks like in order to not do it. And I'm also hoping that the Title IX regulations will address issues beyond sexual harassment. So the reporting is that these regulations will very explicitly make clear that Title IX protects queer and trans students, which is perhaps unsurprisingly something that the Trump administration did not always believe. I'm hoping that they'll increase protections for pregnant and parenting students. And I also have my fingers crossed that the regulations might do more to address sex discrimination and dress coding, which is a really big problem, but one that the courts and the Department of Education have historically overlooked.
And speaking of the timeline, I think people should remember, if I'm remembering this correctly, that under DeVos, the changes happened, I think, in summer of 2020. So it was well into the Trump administration when those changes were made.
Yes, absolutely. And we know that this was basically the Department of Education's biggest priority under Trump. And it took them so many years to get them done. So I want to be clear that is not an excuse for this Department of Education to move slowly. I really had hoped that we would see proposed regulations before now. I will be very, very mad if we do not get them this month. But I think it's helpful for students to understand a little bit of what the delay can be attributed to, and that it's not just that this administration doesn't care about survivors.
And I'm curious as to, I mean, they must be working with some organizations, right, to help shape the language, presumably.
The department did a series of public hearings, what was it, last year, where anyone could come speak about what they were hoping to see from the new regulations. So that was definitely some formal organizations on, both sides of the aisle. But also a lot of students spoke. A lot of ordinary people said, "Hey, this is what I need at school to feel safe." So, I think what the department is trying to do with hearings like that and with the upcoming notice and comment period is make sure that, yes, it's hearing from expert organizations, but it's not getting a slanted view, that it's hearing from real people about what they need, which is important both to get the rules right and also for credibility in order to make clear that the department was open to all kinds of views and, weighed their merit before coming to its conclusion.
In your book, Sexual Justice, there's this really interesting chapter. Well, all of the chapters are interesting, but there's one that caught my attention. It's about the police. It's titled Why Not the Police? And it talks about the role of police in dealing with campus assault versus, dealing directly with the school or with the school only. And, it's a real conundrum. I mean, what is the right thing to do here? And is there a role for police in this process?
This is, a big question. So the reason why I felt the need to address this in my book is that whenever I'm talking about sexual harassment in schools or in workplaces or with any other kind of institution where survivors are turning to the institution and saying, I need support from you. I need you to investigate. I need access to mental health care or anything like that. The number one question I get asked is, why does the institution have any role in this? Why does a school or a workplace or a political club have to respond to this kind of harm? Because shouldn't all survivors just go to the police? And I understand why people have that instinct. That was the instinct that I had before I started doing this work. But as I talk about in the chapter, there are just a million reasons why survivors don't report, and they're good reasons. They know, and I should make clear, why they don't report to the police. There are, police have some of the most backwards beliefs about sexual assault. And so a lot of survivors who report are just automatically disbelieved by police, often because of their identity, because they're a person of color, because they are a sex worker, because they use drugs, because they're a man. And there are a lot of, there are surveys that show that a lot of police just don't understand that anyone other than a woman can ever be sexually abused. And a lot of people end up criminalized themselves when they report to the police. There are all kinds of horrible stories about particularly victims of domestic violence calling the police and the police arresting them rather than their abusive partner. And even if someone reports to the police, even if the police are open to investigating their case, a tiny fraction of reported sexual assaults are ever prosecuted. And survivors don't get to make the decision about whether a prosecutor is going to take up their case. That's a decision that the state makes. So there are survivors who want to see their case go to trial, and a prosecutor just says, I don't know that we can win this one, or this isn't a priority, or, this doesn't seem, like the strongest case to me. And so, too bad. And then even if a case is, a sexual assault case is prosecuted, even if a jury returns a verdict saying, yes, the sexual assault occurred, the remedy that's usually available at the end of that is just incarceration. And there are a lot of survivors who don't want to see the person who sexually assaulted them incarcerated. Maybe because it's someone who they're close to, maybe it's a family member, and, maybe incarceration just isn't going to do anything for that. So, for all of those reasons, the criminal justice system alone is really unlikely to be able to address a survivor's needs. When I talk to survivors, so often what they say is, what I needed most after I was, sexually harassed, sexually assaulted, was I needed to have my shift changed so that I didn't have to be in the restaurant at the same time as, the coworker or the boss who was sexually harassing me. Students will say, I just needed, I missed a bunch of school after I was sexually assaulted. I want to be able to not share a classroom with the person who hurt me. And I want some tutoring to help me catch up on everything that I missed. And the police can't provide that, even if, the police just aren't well positioned to respond to those kind of really immediate needs. And so for that reason, it's true that there are some survivors who are interested in criminal responses, but I feel really strongly that, even for those people, the criminal justice system alone is never going to be enough.
Right, like, even outside of those settings, outside of the educational setting or work, the police aren't really equipped to help sexual assault survivors, right, for a number of reasons. I mean, we can go into that, but there's another reference in your book to Kate Manne, the philosopher and author Kate Manne. She wrote the book Down Girl, about misogyny, and that completely changed my worldview about the definition of misogyny and what it looked like. I did an episode with her a while back about redemption and what the redemptive arc would look like for people who've been accused, right? And we talked about Louis C.K. and we talked about Brett Kavanaugh and had some other guests on the same show, but I don't think that we reached a conclusion because it's a really hard question, like what the redemptive arc looks like, especially when the act did not reach the level of criminality. What's your take on that? What does a redemptive arc look like so that it, helps survivors and is fair all around?
I will say, I think that there are a lot of things that are helpful to survivors that have nothing to do with the accused, right? So I think there are a lot of survivors who, first and foremost, are looking for access to mental health care, who are looking for the kinds of seemingly small changes we were talking about, like getting their shift changed. They want someone to talk to and to support them. They don't want to be exposed to further harm. You can provide those kind of supports to survivors without any concern for whether the accused is taking responsibility or anything like that. So that's sort of always my starting point. There's then a separate question of, okay, what could someone who has caused sexual harm or any kind of harm do to show that they are worthy of forgiveness, if not from the survivor necessarily, from the public, or even if not forgiveness, that they are should be allowed to sort of re-enter public life. I think that that can look like a lot of different things, but I think it has to start with an acknowledgement of harm from the person who caused it. And that's just incredibly rare to find. I mean, Louis C.K. is interesting in part because he at least started with a quasi apology. Unlike a lot of these famous men who have been accused of sexual harms, he basically admitted that he did it. But even then, he wasn't able to come right out and say unequivocally, I did it and it was wrong and I'm so sorry. He still felt in his initial response the need to explain why he thought it was okay and never kind of quite brought himself to say sorry directly to the people that he had harmed. So I think that we spend a lot of time imagining what these famous men would have to do for redemption. But I feel like all of them, or almost all of them, haven't even taken the very first step. So it's really hard to imagine what would have to come after that.
Right. And I think this is related to your answer about law enforcement. I mean, for me, a punitive response doesn't do what we'd ultimately want necessarily in these cases, right? Because it doesn't prevent the behavior. And what we want is to protect future people from becoming victims, right? And I don't think we have good answers as to how to prevent, because nothing's preventing Louis C.K. from doing that again. Nothing, right? And I think ultimately that's kind of what we want on that side, whether he, has a terrible life for the rest of his life, but, I don't know if I care about that, but I just want him to not harm other people.
I think that that's absolutely right. And look, I think that punishment or consequences can be part of a holistic response. So, for example, if you have a boss who is sexually harassing his or her subordinates, that person shouldn't be the boss anymore, right? Maybe you have one conversation with them to see if they can start changing their ways. And if they can't, that person just shouldn't be in a position of power over others because they're going to abuse it. And so I'm totally cool with that person being fired. What I think is important is that it's not just about exacting punishment for punishment's sake. It's about protecting other people going forward. It's about setting really clear community standards that this kind of conduct won't be tolerated. And I think what focusing on the purpose of punishment like that does is it highlights what else is needed. Because once you think about why you're firing the boss, you have to focus on the fact that that's not going to solve everything. That's not necessarily going to ensure that the people that they've already sexually harassed feel safe in the workplace, that they feel like they are able to come to work every day. And maybe they need other kinds of support to continue forward. So I'm comfortable with punishment as part of a larger response, but yes, on its own, it's just never going to be enough.
Right. I want to be clear. I am comfortable with firing the boss. Always fire the person if you can, right? But you can't really fire Louis C.K. And I know that
Yeah.
there's been a lot of criticism about him getting gigs again. Or let's say there's a college athlete and, maybe he has punishment at the university level, but that doesn't stop the behavior. He'll go to another university, he'll go to graduate school, he'll go to work and he'll harass someone there. I guess I'm looking for something holistic, and I don't know if we have those answers to kind of, stop the behavior outside of kind of a criminal environment, right? Where they're supposedly rehabilitated, I guess.
I hear you on that. And look, I would like to think that if someone gets fired from their job or suspended from school for sexually harassing someone, that they will think twice before they do it again. I understand that clearly that's not going to have a 100% success rate, but I hope it would at least give them pause and there would be a lesson in there. But I think what you're getting at is that ultimately stopping sexual violence is not going to be an individualized process. It's not about chasing down all the bad people, all the bad men, and changing them one by one. It's about changing our society more broadly. It's about introducing young people to the idea of sex with a vision of respect and consent so that they start their sexual lives really concerned about their partner's well-being and pleasure and enthusiasm to be part of the encounter. I think it means changing workplaces so that workers feel like that they're able to speak up, that their jobs aren't, they're not always vulnerable being fired at a whim. And it's only then that harassing bosses are going to feel like maybe there will be consequences to their actions. And so, one answer to stopping sexual harassment is promoting unionization in workplaces, building worker power more broadly. I think that ultimately that those are the most important steps we're going to take to stop sexual violence, these sort of broader efforts to promote equality, to promote justice. But I know, I'll be honest that I know that that can be unsatisfying because we're living in the world as we have it today, and there are survivors who need responses today. So I think we have to keep our eyes sort of on both prizes. We have to keep our eyes on what can we do to help survivors today who are living in the world as we have it today, who need support today, and how can we build a better future where fewer people are sexually victimized in the first place.
I'll keep my eyes on the Biden administration and see what they come up with. But otherwise, thank you so much, Alexandra Brodsky. Thank you for writing the book, and thank you for joining me today. It's a really important conversation.
Thanks so much for having me and for exploring these tricky topics.